And this is where the anti-gunners like to get us. And they do a great job, because they will tell you that the import of Bruen is that Bruen struck down the proper cost standard in New York to get a gun license. I don't care about that. That's not what Bruen said. What Bruen said is that when there is a law passed, it is presumptively unconstitutional if it burdens the Second Amendment. And the burden is on the government to prove that in the history and tradition of the Second Amendment, that this regulation was traditionally part of the Second Amendment. Another way that I like to say it is, the import of Bruen is that if people sitting around the table in 1791 were talking about the ratification of the Second Amendment and the Bill of Rights, and we're saying, yeah, well, everyone knows that even with the Second Amendment, you can't carry a gun outside your home unless you take an 18-hour class, then that type of regulation is permitted. But if that was not the conversation around the kitchen table in 1791 when the Second Amendment was ratified, or in 1863 when the 14th Amendment was ratified, then it's unconstitutional. So that's the lens that we have to analyze every new anti-gun law against. More importantly, that's the lens that every judge needs to analyze laws that violate our Second Amendments against that. The Supreme Court is going to have to weigh in on it. And I think that they probably underestimated just how evil some of these government officials are and what lengths they will go to try to take away our Second Amendment rights.